So now we can do the swear to on Felicia Davis. You have that file?
I do, sir.
All right, calling prosecutor order number 26-15528, People State of Michigan versus Felicia Davis. Detective, you have identified yourself for the record.
Okay, I got all sorts of good stuff. Of course, Zach over at LawNerdsUnite, and also Lakificent's Lair. It's just a crazy bunch of stuff. Let's do it.
This forum, please proceed with the facts established probable cause.
Sir, on January 9th of this year at approximately 5 p.m., deputies of the Oakland County Sheriff's Office were on routine patrol in the area of Woodward and Pike, traveling west on Pike towards Mill Street behind a red Honda Accord bearing Michigan license plate David John Robert 8721. While deputies were traveling behind the Accord, they observed that the driver, who was later identified as Felicia Davis, swerved to the right quickly, almost striking the curb. Deputies ran the plate and found the vehicle to have an expired registration as of 2023. They initiated a traffic stop at in the area of Saginaw, Huron, in the city of Pontiac, and the driver was identified, and the sole occupant of the vehicle was identified as Felicia Davis. They requested Ms. Davis to step out of the vehicle to conduct an investigation as to her sobriety, and they found her, once she exited, to be wearing only a t-shirt and no pants. They found her to have an outstanding warrant for assault. She was also listed as a missing and endangered person in lien. She was arrested for her warrant.
If she's pantsless, she's innocent.
On an inventory search prior to impound of the vehicle, the deputies located a brown, rocky, powdery substance in a plastic tie bag on the driver's side door compartment just below the window controls. A field test for this item tested positive for the properties of heroin. They continued the inventory search and located on the passenger side front seat a white grocery bag that had an aluminum wrapper with a plastic bag corner tie in, which also contained a brown, rocky, powdery type substance. That field tested positive for the properties of heroin. Ms. Davis complained at that time of chest pain, so she was transported to the hospital for an evaluation. Read her Miranda rights, and she agreed to speak with an attorney present. She stated that the heroin that was located in the vehicle was hers, and that she had been a heroin user for several years. Ms. Davis is currently being evaluated at Clarendon Hospital due to the fact that while she was there complaining of chest pain, she was diagnosed with pneumonia, but she remains in custody and is being guarded by deputies from the Oakland County Jail at this time.
All right, and so she did not have a driver's license when she was pulled over in the vehicle?
She did not, no, sir.
And then the one count for operation without security, is that because there wasn't insurance on the vehicle?
That was based on the lien review at the time of the original traffic stop, sir.
All right, the court finds that alleged crimes are committed probable cause of believe that Tank committed them. I'm not going to be arraigning Ms. Davis today. I may be arraigning her tomorrow if she gets out of the hospital. If I do arraign her tomorrow, what are your thoughts with respect to any bond that might be set?
I guess the only thing that I would add outside of just a routine possession of opioids and whatever consideration you weigh on that, I was.
And maybe keep your pants on.
The detective that was assigned the original missing persons complaint for Ms. Davis. She was listed as a missing person by her family on January 2nd after she called her granddaughter and asked for directions to Southfield. After that, she refused to communicate with them. They had no knowledge of where she was. And I don't know if that is secondary to her opioid use or some other factor, but if you could just keep that in mind and apply whatever weight you feel appropriate or not appropriate to with that piece of information.
All right, thank you very much, Detective. Enjoy the rest of your weekend. Thanks for calling in.
Yes, sir. Have a great day.
Good morning, Detective. Can you hear me?
Good morning. Yes, I can.
Are you calling to do the swear to on Michael Grenon?
Yes.
All right, please identify yourself for the record.
Detective Plesher with the Waterford Police.
All right, you solemnly swear from the testimony you're about to give to the best of your knowledge, information, and belief.
Yes.
All right, please proceed with the facts established probable cause.
Yes. On 12/29/25, I reviewed Waterford report 25-43163 and noted the suspect truck, a dark Ford F-150 with a plate of PNJ9145, was used to steal a furnace out of a house in Waterford. I recognized the truck as one I had seen previously on that day during surveillance. I contacted Donald Lee with Enterprise, and he informed me that a Cassandra Grenon had rented the truck and provided other identifying information that was consistent with a Michael Grenon. I recognized Michael Grenon as the driver of the truck I saw earlier that day. I obtained location data for the truck from Enterprise. I began investigating the truck and Michael Grenon has a history of theft. I noted at some point the truck was driving around without a tailgate. And then I noted that another report had been made, Waterford report 26-734, and that a truck matching the description of the Ford F-150 rental was used to steal a tailgate from Suburban Ford at 6975 Highland Road in Waterford on January 5th, 2026, around 7:20 in the morning. This was consistent with the rental truck location data. Robert Reed with Waterford Suburban Ford valued the tailgate at $3,000. Per the location data, the truck then went to Lowe's at 8550 Highland Road in White Lake, within a mile of the border, on January 5th, 2026, around 7:36 in the morning, just shortly after. I contacted Kyle Kinnery with Lowe's Loss Prevention. He provided video and confirmed a truck matching that description was there. An occupant got out, went into Lowe's, and stole some bolt cutters. I reviewed those photos and determined it was Michael Grenon, who I am familiar with. That person who stole the bolt cutters went outside, and they used the bolt cutters to cut the chain to a Ariens snowblower and loaded that into the truck. And then they left. There's 3 suspects. The Ariens snowblower was valued at $2,100, and Lowe's has a flat camera in their parking lot, and they determined the plate on the truck was AIS 231 out of Nebraska. The rental truck location data then put the rental truck at Main Street Pawn at 20 North Saginaw and Pontiac, where there is a pawn
I'm just waiting to see if he stole an attorney to come in here and talk for him.
receipt for Michael Grenon pawning an Ariens snowblower. He used his ID and his thumbprint. We arrested Michael Grenon on January 8th, 2026. He was driving the rental truck, and we arrested him in Pontiac, and it had a different improper plate on it over the original Ohio plate. We executed a search warrant at Michael Grenon's house at 83 South Edith in Pontiac and found the original rental truck tailgate in his yard, and it was damaged, assuming he damaged it and went to steal a new one, so he didn't have to return the truck with damage on it. I presented the case to the prosecutor, and they authorized the noted charges.
All right, the court finds alleged crime was committed. There's probable cause of belief that they committed those. What are your thoughts with respect to bond? I'll be arraigning Mr. Grenon a little later this morning.
I would say he has a very, very lengthy criminal history, and I do anticipate more charges coming. At the execution of the search warrant at his house, we did find a stolen firearm in his bedroom, and we are still working on the theft of the furnace, and I anticipate we will get probable cause for that, but that is forthcoming. He is a drug user. I'm not clear if he's working or simply stealing to support his habit.
So do you think a bond somewhere in the neighborhood of 50,000, cash sure 10% would be appropriate?
I think so, sir.
Okay. All right. Very well. Thank you very much for calling in. Enjoy the rest of your weekend.
Hey, thank you. You too.
All right. Bye.
Bye.
Good morning. Please state your name.
Michael Grenon.
All right. Calling case number 26-15520, People State of Michigan versus Grenon. You've identified yourself for the record. Counsel, please put your appearance on the record. I'd like to proceed.
Yes, good morning, Your Honor. Jeffrey Glazer, P46892, on behalf of Mr. Grenon. I did have a chance to meet with Mr. Grenon, and I advised him of his rights. I also advised him of the charges against him, as well as the maximum penalties. He will need a court-appointed attorney at the next hearing. Waive the ratings can be discharged.
All right, I'll enter and plead not guilty for purposes of arraignment. I'll advise the defendant he's presumed innocent, so proven guilty beyond a reasonable doubt. He's got the right to a preliminary examination within 21 days, where the prosecutor must establish that This crime was committed. There's probable cause to believe he committed them. He's got the right to try his matters by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney if he cannot afford one. The court appoint one for him. Does Mr. Grenon want a court-appointed attorney going forward? Does he appear to qualify?
Yes, Judge, he would like the assistance of a court-appointed attorney, and I believe that he does qualify, Judge.
Okay, very well. You may address bond.
Client's 54 years of age. He's a long-term resident of the area, Judge. He has one biological child, 2 stepchildren, Judge, that he's responsible for. He's self-employed as a builder. He's not currently working right now at this point in time. I'm asking for a personal bond or a nominal cash bond, Judge. I don't think he's a flight risk. He has strong ties to the community.
All right, I appreciate the argument. The court's got some concerns with during the extensive history of Mr. Grenon. There may be other charges pending. So in order to ensure Mr. Grenon's appearance and ensure the safety of the public, court's going to set a bond amount of $50,000 cash surety. The conditions that he not have any contact with Robert Reed, not return to any suburban Ford location or any Lowe's location, that he not harass or intimidate any witness, that he appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or telephone number, not possess firearms or dangerous weapons, refrain from using any alcohol, marijuana, or legal drugs, no criminal offenses, and pretrial services supervision. Next court date is a probable cause conference set for January 20th at 9 a.m. Mr. Grennon's preliminary exam is set for January 26th at 9 a.m. Both of those at the Waterford District Court. All right, you're all set, Mr. Grenon. Good luck.
It was hard for me to understand how much you said. I just didn't. Can you repeat it?
Yeah, 50,000.
10%.
No.
Okay.
All right, you're all set. Thanks. Good morning, detectives. Can you hear me?
I can. How are you?
Great. All right, calling case number 26-15524, people of the state of Michigan, which is Cory Martin Jr., was alleged on or about January 9th in the city of Orlando. The accused committed offense of retail fraud first degree. Detective, please state your name for the record.
Detective Zach Meckel for Orlando Police Department.
Do you solemnly swear affirm the testimony you're about to give is to the best of your knowledge, information, and belief?
I do.
Please proceed with the facts established probable cause.
Good morning, Your Honor. Again, Detective Meckel for Orlando Police Department. Before you today is a 2-count warrant charging Cory Martin Jr. with retail fraud first degree and prohibited use of chemical agents. The facts of the case are documented in Royal Oak Police Report number 26-871 are summarized as follows. On 1/9 of 26, our OPD officers were dispatched to CVS located at 30900 Woodward in the city of Royal Oak, County of Oakland, state of Michigan. Officers were dispatched for report of a suspect who had come into the store and proceeded to take $235.84 worth of energy drinks out of the store past all points of sale without offering payment. The store reported that the individual got into a black Jeep Wrangler and fled eastbound on 13 Mile Road. Officer Staniszewski located the vehicle matching the description traveling eastbound on 13 Mile Road, west of Crooks Road. This is approximately 1 mile from the store. He noted that the driver of the vehicle was not the registered owner and the vehicle had no electronically verified insurance. He enacted a traffic stop on the vehicle and identified the driver and passenger of the vehicle. Through review of in-store CCTV footage, the passenger of the vehicle, identified as Cory Martin Jr., was identified as a suspect. When looking through the back glass of the vehicle, he noted numerous cases of energy drinks matching what was taken in the trunk of the vehicle. Further, when he approached the vehicle, he observed Martin Jr. to have a large canister of nitrous oxide in his lap. He told Martin Jr. to place the canister on the floorboard of the vehicle. When speaking with the occupants of the vehicle from the passenger window, Martin Jr. picked up the canister of nitrous oxide and began to inhale it. Officer Staniszewski took the canister from Martin Jr. Based on CCTV footage and finding the stolen merchandise in the vehicle, Martin Jr. was placed under arrest. A review of his CCH showed that he had 2 previous convictions for retail fraud. In April of 2025, he pled guilty in the 16th District Court to retail fraud 3rd degree, and again in April of 2025, he pled guilty in the 66th District Court to retail
I mean, seriously, he started doing it in front of the cop? That's insane.
fraud 2nd degree. I believe the information provided is sufficient to prove a probable cause standard. The alleged criminal offense was committed by the named defendant. I have fixed my signature to the criminal complaint and respectfully request the court authorize the warrant in this matter.
All right, the court finds that crimes were committed as probable cause to believe that the defendant committed those. I'll not be setting any interim bond. And reviewing his record, it looks like he's got some traffic warrants out, as well as looks like a Livonia probation with the $1,200 bond. Flint retail fraud, $1,000 bond, Shiawassee. So my inclination would be set bond somewhere in the neighborhood of 50,000, 10%, something like that. What are your thoughts with respect to bond?
No, I agree with that. There's just a long history of retail frauds, obviously, and his
Yeah,
probation
plenty of
violations what mainly worries me.
Okay, very well. All right, thank you very much. He's speaking in the breakout room with the attorney right now. We'll get him arraigned shortly. Have a nice weekend.
Right. Appreciate you too, Your Honor.
All right, calling case number 26-15524, people of the state of Michigan versus Cory Martin Jr. Sorry, Mr. Martin.
Okay.
All right, counsel, please put your appearance on the record. How'd you like to proceed?
Good morning, Your Honor. Jeffrey Glazer, P46892, on behalf of Mr. Martin. I did have a chance to meet with him in the breakout room. I did advise Mr. Martin of his rights, as well as the charges against him, as well as the maximum penalties. He will need a court-appointed attorney at the next hearing. Judge, waive the readings and immune charge.
All right, I'll enter not guilty plea for purposes of arraignment. I'll advise Mr. Martin that he's presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to a preliminary examination of 21 days where the prosecutor must establish this crime was committed and there's probable cause to believe he committed them. He's got the right to try these matters by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney if he cannot afford one. The court appoint one for him, and the court intends to do so in this matter. With respect to bond, the court does note that there are several outstanding bench warrants for Mr. Martin, but you may address that, Mr. Glazer.
Yes, Judge, thank you. My client is 27 years of age. He's a lifelong resident of the area, Judge. He was working at general staffing, working of metal parts, the General Staffing Corporation, Judge. He's not, I don't think he's really a fly risk, Judge. He's got a 3-year-old daughter. He's a sole support for that daughter. He needs to get back to his child. I know he's got a few blemishes there, Judge, but I'm hoping he's going to be able to take care of those traffic warrants. I'm asking for a personal bond or a nominal cash bond.
Very well. In reviewing the file, it looks as though there's a number of traffic warrants as well as 1, 2, 3, 4, 5 outstanding cash bonds from various courts. So in order to ensure the appearance of the defendant and the safety of the public, I'm going to set bond amount of $50,000 cash surety or 10% with the condition of Mr. Martin not return to any CVS location, that he appear for any court proceeding, not leave the state without permission of the court, notify the court in writing of any change of address or phone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, illegal drugs, or not prescribed medications, no criminal offenses. They'll be supervised by pre-trial services, so you must contact within 24 hours of his release. Next court date's a probable cause conference set for January 26th at 9 a.m. January 20th at 9 a.m. His exam is set for the 26th at 9 a.m. Both of those at the Royal District Court. All right, you're all set, Mr. Martin. Good luck to you. Thank you, Royal. Have a good weekend.
I have a $50,000
10%. All right, thanks.
Hamilton Crossing versus Veronica Whitsett.
Good morning, Your Honor.
Jillian Engen for plaintiff.
She's here. Hello, Ms. Whitsett. How are you?
Good. How are you?
I'm well, thank you.
Happy New
All right.
Year.
And to you. And to you. What is plaintiff's claim in this case?
I have a balance including court costs of $1,745.
That's not true, Your Honor. So
Uh-oh.
I've
Okay.
been listening to the other testimonies, and I could be using the wrong terminology. I feel like they're extorting court costs because I called them on the 13th. No, I'm sorry. It was like the 14th or the 15th, whatever day of Monday was in December.
Well, you're using the right word to make your dumb allegation. But, where are you screwed up in this particular circumstance? I'm sure the language will deteriorate, but it wasn't language. It was opening with, I feel like. Because you know what? We don't care.
And I told them that I had $950 and I would pay the other $950 on the 27th. They agreed to it. And so once she agreed to it, I didn't have any court papers or anything. So when I went around there and I made the payment, she told the clerk to call. I heard her as I was leaving out, tell her to call the lawyer. Call the lawyer for what? We just made payment arrangements. You get what I'm saying? So then once I left, they sent me court costs and they never entered in my $950 payment. They never entered it in. They never brought me a receipt or anything.
Your Honor, I have a couple things. First, I want to note that this case was actually signed on the 16th.
And I went the 15th.
Ma'am,
I went the
ma'am, Ms.
15th.
Ms. Whitsett,
I'm sorry.
I listened to you, so
Okay.
now I'm going to listen to the other side. All right,
Okay.
go ahead, Ms. Whitsett.
And I do see a payment of $950 from the 17th. I did want to ask about whether there was a second payment in December. Ms. Woodsett, were you able to make a second payment?
I did not make the second payment because I got court papers attached to my door saying that I owed the full amount. So by this time, I'm angry and I want my day in court because why would they make payment arrangements with me and then come and put this embarrassing notice on my door when we
Okay, Ms. Whitsett, Ms.
I'm
Whitsett,
sorry. I'm a
Ms. Whitsett, here, let me try to calm you
Probably because you didn't pay your stuff.
down. The reason that the plaintiff's going to do that is they have to protect their interests.
Got you.
Because if you don't follow through, they've got to have a way to try to collect the money. Okay?
Yes,
So
sir.
I get what you're saying, and maybe they should have explained it a little bit more clearly,
Mhm.
but I don't think they're trying to extort you or to try to do anything, because if I felt that way, then I'd tell them, and
Gotcha.
it'd be an all-out
So shut your hole.
Zoom brawl going on. I do not,
Gotcha.
I
I
don't,
do
I
want to
don't
let
think,
Ms. Woodsett know that they actually end up paying more than what they're able to collect from you. So whatever they put on their ledger is determined by statute, but it's not necessarily what they end up paying to get the case filed. They pay more.
Gotcha.
Right.
So my next question is that the right amount? Because I paid $950.
Yes, and I do see that on the ledger. And so that brought your balance down to $939, not including court costs. And then I see January rent added of
Right.
$580, and then a late fee for January and court costs.
So how much is it now, sweetie?
$1,745.
Okay. All righty. Well,
you got angry, Ms. Whitsett, you got angry. You just wanted to talk to me, didn't you?
I did. Per usual.
All right, Ms. Whitsett.
Yeah.
How are you gonna try to get this paid?
I'm going to. I get paid on the. Let me see. I get paid on the. What is tomorrow? The 10th.
10th.
I get paid on the 10th, but somehow they cut overtime for January. So I have to see what this check is looking like or whatever.
Okay, so let me ask you this, Ms. Whitsett. How much do you think you can pay? Could you give me a number that you think you can pay for sure?
I think I could pay $750.
Okay, that's good. We can start there.
Yes.
All right. So I want $750, and that's out of this check. So I'm just going to say you need to pay that by the 13th.
Okay.
Okay.
Yes,
I'll
sir.
adjourn your case out to January 16th, next Friday, 2026 at 2 p.m. That's an in-person hearing.
Gotcha.
But here's what you can do. You can also call the attorney's office, see if they can arrange a conditional order dismissal with you as to how you're going to get this resolved.
Okay.
Fair enough?
That is fair enough. Thank you so much.
Anything else you want to yell about?
No. No, I was just frustrated. I was like, I gave them $950. Why didn't they put it on there? But I was just a little frustrated. But thank you so much. And
I understand.
I apologize to the beautiful attorney. I'm so sorry for yelling. I was just a little frustrated.
We're good.
She's so sweet. Thank you so much, and Happy New Year to you as well.
Thank you.
You know how it is.
True.
Me and you.
All right, that's fine. No, I'm not insulted. That's okay, Miss Whitson.
Good one, Judge Simpson.
Okay, you take care.
Bye-bye.
Bye-bye.
Kelvin Simons versus Mary Cotton.
I'm here, Your Honor. I'm here, Your Honor.
Come on up.
Your
Ms.
Honor,
Cotton's here.
may I ask Your Honor, this is being live streamed, right?
Yes, sir. Why?
No, I was just curious. I'm also a content creator myself, so I was wondering, would I be able to record or live stream it on my end?
No.
It's just for educational purposes, just because it's my first time going through this, just for education.
I'm not running. I don't have any.
I agree. It's great for educational purposes. People need to learn how to not be a big dummy like you. And did they say his name was Mary Cohn?
Control over the live streaming, and I don't know what the court had set out. So they're live streaming it. That's okay, but you can't. I don't think recording it is proper.
Okay. No problem.
Okay. I'll hear from the plaintiff. Where's Kelvin Simons? All right, tell me why we're here.
All right. I'm just here, Your Honor. Today, this is a Padsplit co-living property. The defendant tenancy was terminated by Padsplit effective November 17, 2025 for co-living violations. She did not vacate. I served a written 3-day notice to vacate on November 27th, which was posted on her door. She still remains in possession. I'm just requesting possession of the property based on holdover and lease violation.
Barely understood him, but yes, sir.
Fair enough. I understood him. That made sense. I'm shocked. After that opening, I thought it would just be complete nonsense. I know what the hell he wants, at least. I'll give him credit.
Did you understand me, Your Honor?
Yes, sir. Yeah.
Okay, no problem.
What is the lease violation?
So the lease-based violation, this is a Padsplit, right? So it's 6 people that live in the same house. I've been getting constant complaints about like Mary not making a comfortable co-living experience. And since she's moved into the house, like it's been just chaos. Everyone texted me and calls me every day. So I went down to the house myself to talk to everyone. And then I was like, I thought I came to like an agreement, like, are we okay? Should be no more problem. But since then it's kept being an issue to the point where Padsplit has contacted me themselves and said I had to either evict either Mary or the other tenant that kept getting complained from the other pad mates. So I already talked to her about this, and that was the issue. Not creating a safe co-living experience, basically.
All right. What is the rent?
Okay.
It's $140 a week.
Is this one of these very often illegal flop houses, whatever they're called?
All right. Okay, I'll hear from you.
Rent is not the basis stated in the notice to vacate or the court filings. This case turns on notice.
All right.
Co-living generally just wasn't a good fit, Your Honor. And that's why she was asked to vacate. And then she refused to for about a month now.
All right. Okay. So where are we?
May I read something else?
Well, yeah.
Your Honor?
Yes.
Before addressing the notice, I need to briefly clarify the legal relationship at issue in the case. I did not enter into a lease or rental agreement with the plaintiff, Kelvin Simons.
So who did you enter it with?
My agreement was a membership agreement with Padsplit, the platform that controls payments, communication, rules enforcement, and membership. I communicated with Padsplit through its online portal and app, paid Padsplit directly, and submitted maintenance and safety complaints through Padsplit's system.
All right, let me stop right there. All right, so what authority do you have to bring this action?
Me? You're talking to me?
Yeah, Mr. Simon.
So I am the Padsplit owner, and I'm the owner of the Padsplit, and I'm the landlord. After Padsplit has terminated her contract, they emailed me and said I have to go through a regular eviction process to have her leave. So the way it basically works is Padsplit is like an Airbnb, right? Where you put your house on the platform, and then they'll sign up through Padsplit to live in my house. You understand? So then basically she got terminated with Padsplit. So the contract she already had with Padsplit was terminated, and I'm partnered with Padsplit. Since she got terminated, she was supposed to leave on November 17th, and she's been there since. And she was ordered to leave by Padsplit November 17th.
I mean, this is a mess. We didn't have this stuff before. I've never really seen this shake out. I will give this guy credit. Throughout this hearing, I know what he's asking for, and he's straightforward about it.
Okay, so have you since since November 17th, have you made payments?
Yes, sir. I made a payment on November 23rd through the Padsplit.
Okay, did you make any payments in December?
No, I haven't been able to. The platform I can't pay through the platform.
All right.
I need to pay Padsplit, not him. And rent is not the basis. He served me with an illegal notice to vacate. It wasn't posted. It was posted on the back of the front door, open face, not addressed to me. And
Your Honor, I have a
there
video
for everybody to see.
Your Honor, I have a video of me posting the door, the Padsplit on the door, then going to her door as well and telling her that you have to vacate. She was in the room, Your Honor. I can show you the video if you would like. And the thing about
I don't need to see it. I don't need to see it.
Okay,
Right.
no problem.
Yes, sir.
Okay.
I didn't understand what he said.
He said he has a video and he
good.
posted it on the door. I don't need to see that. All right.
Back of the door, but it wasn't addressed to me. It wasn't in an envelope, and it was on the back of the door, taped, open face for the whole house to see. That is not a legal way to serve a notice to vacate.
The way I see it, it ends up being at some point a public record because all of these are public records.
Okay, it'll be public
all right.
record.
Anything further?
No, I'm just calling for possession, Your Honor.
All right. It's a judgment of the court, the plaintiff recover possession of the premises. All right.
Well, I will be appealing that.
Okay. This is not a court of record. You have an absolute right to appeal the court's decision. All right. Good luck to you.
Thank you, sir.
So, Your Honor, I would.
So he won, and he should have. Good.
Be able to go down there right now and then have like how would the next? Because this is my first time going through this process. So how would it go about now if she's not going by like tomorrow, or how do I go about it?
You'd go about getting an attorney, because your next move is to get rid of eviction and have the sheriff throw her ass out. You're probably going to have to do that, and you're probably going to screw it up without an attorney. You've done well so far, but let's not press our luck here.
Well, you have a judgment, and then after 5 days, you can come and get a writ of possession from the court that orders directs the constable to go there and ask her to leave. All right.
Except I will be filing an appeal.
I understand.
So she has 5 days.
Yes, sir. Okay, I'm sorry.
You may leave. All right. Sorry about that, Your Honor. I truly do apologize. But I just wanted, this is my first time. Can I ask any more questions, or am I taking up your time?
No, I can't give you legal advice. I can try to give you some direction, but I can't give you legal advice.
Okay. I'm not asking for legal advice, Your Honor. My fault.
All right. There you go.
Thank you. Thank you.
Invitation Homes Realty versus Lawana Hall. Miss Hall.
Okay, that was weird. I just assumed that was going to be absolutely horrible, because his first question, which is stupid, is, can I stream this? That was stupid. Everything else was rational and on point. He made sense, and it's actually kind of a messy little deal, but he made sense in the way he articulated his attempts at service and everything that was on point and what the judge wanted to hear, and he actually prevailed. But to actually get her out, it's another issue.
Yes, Joaquin Rodriguez here from the plaintiff, Your Honor.
This is from Maleficent. This judge is fun. Oh, not again. It was working when I played it. Let's see if it gets better.
Okay.
All right, I got to just figure out how to fix this sound.
To grant your divorce, discuss the contents of a final decree of the.
But I got to fix this.
Number 25-09-0661-CVA.
Which is weird because I downloaded it and I played it on my computer and I could hear it and it didn't sound like that. It sounds terrible now.
In the matter of the marriage of Wunsch and Wunsch. I hope I'm saying that correctly. Mr. Clayton Wunsch, I see that you need to unmute yourself.
Yes, sir. I'm here.
All right, there we go. And is anyone else here on that case?
For me?
No, I'm looking for, well, I see that there's another gentleman here that just says Zoom user.
This is divorce and it's awesome.
So are you here on a case with Wunsch?
Yes, sir. Happy.
No,
Your Honor.
Yeah, go ahead, Ms. Mendez.
Yes, I'm here, Your Honor. I couldn't unmute. I'm sorry.
And how are you related to this case?
I'm the person who is filing for divorce.
Okay, so we have the husband and the wife here, correct?
Yes.
Just a second.